Thank you very much for joining us today. We are very pleased that you have joined us in this noble discussion that we'll have today. Being a Christian institution, we'd like to start with a prayer. So Ann Kariuki will pray for us.
Shall we believe and pray? Our good Lord, we're so grateful for this afternoon. Thank you for this opportunity. Thank you for gathering us here. Thank you for Prof, and thank you for granting him journey mercy. So God, even as we traveled here, and even as we seek to dispense wisdom from him, even as we seek to hear from him, dear Lord, we seek wisdom, we seek knowledge, we seek understanding, O God. Pray that you'll be with us as we begin up to the end. For it is by faith we pray, trust, and believe. Amen.
Thank you very much, Anne. We'd now like to have our national anthem, so we'll rise for that. We have Gibson, the violinist, to perform that for us. Welcome, Gibson. We'll just stand in honor of the anthem. Thank you, Gibson. Thank you, Gibson. Thank you. And with that, we'd like to start. When we put out a call when we were organizing this event, we just imagined we'd be talking about judicial dress and address. However, we have had some unprecedented events happen since then. And most concerning for the judiciary at the moment is the passing away of our beloved Justice Majanja. So we'd like to take a moment before the program begins to just remember him in silence. So we'll just take a moment of silence in memory of Justice Majanja. Thank you. Thank you. And with Justice Majanja in mind, the program had to change a little bit. So we'll not start with the lecture immediately. We'll have Professor Chief Justice Emeritus Willy Mutunga and Professor John Osogo Ambani take some minutes to just talk about Justice Majanja and his legacy and how he touched their lives, just as a way of remembering him and the good work he did while he was with us. We can perhaps start with Professor John Osogo Ambani. He'll take very few minutes to just talk about his mentor. Welcome, Professor.
Yeah, I said that I hope you are doing well and ready for the conversation that we are just all going to have. As our moderator mentioned, a friend has passed away, passed on, I think 2 days ago or so. that is Justice Honorable David Shikomera Majanja. People will say many things. I'm sure you've read a lot of things about his contribution to jurisprudence, to the law, and all those kind of things. But for me, I want to just slightly, maybe 2 minutes or so, about the contribution to me and my group. I'm sure you've heard that God gives a friend for a season, and that life has different seasons, and God provides the people you need for those seasons. For me, there are seasons when I needed Majanja, and he was there for me. It begins late in my undergraduate. Mr. Majanja was an associate partner at the Mohammed Mugai Advocates. Then we didn't know many people. If you can imagine, if you're coming from the village and going to the city, you don't know many people, or maybe you know a few people who are not very high ranking. But here is an advocate that you get to know, and he treats you very nicely. Occasionally would go to Mohammed Mugai. And when we are there, you didn't know the difference between him and us. He would treat us very humbly, very kindly, and he really, really supported us. In fact, I'm sure Ongoya will tell you later, if he hasn't already, he eventually became Ongoya's pupil master. Again, my wife went to the same law firm, and again, Majanja was in charge of her as well. So for us, there was that personal connection. And then around mid-2005, I think around June, July 2005, Majanja was admitted to the University of Pretoria. There's a program there in the Center for Human Rights called Trade and Investment Law in Africa, TILA. So he goes there, and then I'm admitted as well to that program beginning January 2006. So by the time I'm going, Majanja has done 6 months in Pretoria. And as soon as I land, Majanja becomes like the person who's gone ahead of you, you know, taking you around, helping you settle down. At that point, you've never lived away from home. You've always just been in Kenya. And it was really, really there for us. Part of the things I remember him for was, and actually I call him my Baba. I'm writing a tribute at the right time, I'll be able to share it. I call him my Baba. Because the time we were in South Africa was a very difficult time there. For example, the issue of HIV prevalence. It was a pandemic at that point. You couldn't even go to a barber. Okay. In any case, in Pretoria, some barbers told you that they don't know how to shave black hair or African hair. It was racist, but they would get away with those kind of statements. Eventually, they were sued actually in court. But nevertheless, what Majanja had done, since he had come early, he had bought how do we call it? The machine that barbers have. And so he would come to our house frequently, would cook together. Then if my hair was bigger, Majanja would actually shave me. So from that time, I never called him Majanja again. I would call my Baba. Even when he's judge, I would just say, oh, my Baba, how are you? And many people would not understand what I've said. So we do that. Sometimes I would even send him here with errands. So if you're in South Africa, those days, it was the days of WhatsApp. It was the days of, they were a bit difficult. 2006 is not far, but it was still very difficult. You want something to get your mother or your friends or your relatives, you'd actually carry them for me and deliver. Yet he was a very senior, it's almost 10 years senior in the profession. But he would do it for me. He was such a very good person. And then he came back to Kenya, I remember, and came back 6 months earlier. And actually in his class, he had been classmates with Murkomen for the trade thing. And then there was another friend of ours who eventually became a member of parliament for Ugenya, David Ocheng. Majanja supported us to open an office. Because when you come back to the country, you don't even know where to start. I had resigned from my civil society work to go and study. Now I come back, I have no single shilling. I don't know where to go. And Majanja actually helped us open an office, furnished it, and we began work. And from there, life was never the same again. Of course, the sad part was that somebody came and stole the entire things that he had purchased, computers, furniture, and all that. But we always remember that when we really needed him, a moment of transition for us, Majanja was there, and very kind and supported us, including with a lot of money. That kind of generosity is actually unrivaled. So for me, I'm still really very disturbed. I've been moving on, trying my business, but it's been very hard to move on normally. I think it's good to talk. Then maybe we heal and can go on with business as usual. So it's good we spend some time, and I thank you for listening to us and being here. And I thank CJ also for being part of this so that we can mourn our friend. And CJ, maybe I should thank you because as soon as Majanja came back, I think in 2006, he was appointed to a commission of inquiry, I think, 2006, 2007. Then soon thereafter, CJ appointed him High Court judge. And Majanja became one of those faces of judicial transformation, in my view. There were judges at that point that stood out when Chief Justice was there. One of them was Majanja, there was Mumbi Ngugi, there was Joel Ngugi, and there was Odunga. I think we've agreed on that. Those are the judges that led the activist judiciary that we now all enjoy, including GenZ have enjoyed it, getting orders, timely orders for them. And that is really where it all began. So for me, that is my contribution today, but I'll be writing. I'm better in writing than speaking. I think I'll do what I can do better later. Thank you very much. Good.
Thank you very much, Prof Ambani. We are very saddened by the sudden loss of Justice Majanja. We hope that soon enough you will find healing, and our deepest condolences to the family too. And now we'd like to hear from a colleague and boss at some point. Welcome, Professor Mutunga.
Yeah, I first saw Majanja in 2012 when he applied to apply for a position of a judge of the High Court. And I still remember the discussions and the questions he answered, and I had no doubt, that he was going to be one of the 28 judges that we wanted to appoint at that time. And we wanted to appoint judges who were academics or corporate, human rights experts, and then the judiciary, and people with magistrates and so forth. And the judiciary has always had that division of saying the people who are external, to the judiciary. And so those of us who are external were the group of Majanja 28, then the Supreme Court, we were 4. So it's a group of 32 judges, and the guys who used to tell us judiciary in our wenyewe, of course there were many. They gave us only 99 days to do our thing and get out. But it's that group. I know Majanja went to the Constitutional and Human Rights Division, and with the people you've mentioned, Mumbi, Odunga, Lenaola, Wasame, Joel Ngugi, and of course Mumbi Ngugi. What was there? There were quite a number. Even the guy who became the presiding judge of the High Court. I'm forgetting his name. It's from Mwongo. Mwongo, yes. I shouldn't have, forgotten his name because when we took him to Mombasa, somebody asked me, "Sasa unaletea judge ambao ni Mwongo." They didn't know that. Yeah, but there is a group of young people who were committed to the transformation of the judiciary. And I always tell people that Kenya has this problem of taking the leader and glorifying the leader without knowing that it's not it's not just a leader, okay? When I look at the people who are involved in the judiciary transformation, there were quite a number of us. People who are good with, who are good journalists, good administrators, good speech writers. And when they started in the High Court, that's when transformative jurisprudence happened. If you look at the case on Mume Matemu, for example, on chapter 6, it's them who interpreted that chapter properly and the vision of it, the history behind it. Before, of course, there's the Supreme, not the Supreme Court, the Court of Appeal overturned it. Those were the time when the Court of Appeal used to be called the graveyard of a progressive jurisprudence. Now it can't be called that because a lot of people have gone there now. So he was one of those, great mind, and I think he's a great loss to the country and, the judiciary, because those are the people I thought once he did his term at the Judicial Service Commission, he will probably be elevated to the, to the Court of Appeal. But yeah, so it's a great loss to the judiciary and the country.
A great loss indeed. Thank you so much for that account. Our deepest and sincere condolences for this undesired loss. We hope that you will find peace and the strength to move on. And once again, our deepest condolences to the family and friends of Justice David Majanja. We will forever remember him. I know for sure that in my class, we used to have this joke about Justice Majanja being Lord Devlin. And yeah, his jurisprudence was one that always stood out. So we will forever commemorate him. Our deepest condolences again. We were not decolonized then, but now we know better. We will not do that ever again. Yes, yes. He was great. He was great in his own way, and we will forever remember him. Now, yes, Lord Denny. Yes. Thank you. We'd now like to transition just a bit to today's topic, which is dress and address in the judiciary. Before we start, I'd also like to note that when this lecture was being organized, we had not foreseen the circumstance that the country is in right now. Right now, you can say the country is undergoing a revolution. Many have said that it's a GenZ revolution. So now that we're here, we could not avoid the obvious. So after the lecture, we will also have a discussion on the GenZ revolution. And I urge all of you to stick with us. But first things first, let's talk about judicial dress and address. And on that, we will invite the man of the hour, the author of the article, the brains behind the ideas, Professor Chief Justice Emeritus Willy Mutunga, to talk to us about his thoughts on dress and address. If you could help me welcome him by just clapping. Those of us online, you can clap on Zoom. Those of us on YouTube, you can give us a like. And Professor CJ, welcome.
Thank you. Thank you. I assume all of you have read this paper anyway, so I'm just going to kind of say what it's about. And I'm reading some paragraphs from it that I think capture the essence of the whole paper. So, a historical, socio-economic, environmental, security, cultural, and political analysis of judicial attire, and formally addressing the judiciary should assist the Kenyan judiciary in reaching a consensus. And this was written in 2011, August 2011. That's the first draft I wrote to convince the judges that we needed to debate this issue. Now, so such analysis will lay bare the ideas of the ruling classes over time, political struggles in society, the dictates of the market as reflected in fashion. There's a lot of talk about the wigs being powdered, you know, fashion changing, and the judges focusing on that. Impact of religion, you know, when you get into this discussion, you realize it starts with the church. Okay, the church, then the kings, then the Industrial Revolution happens, and you then have, you know, classes of rich people, and the judiciary, of course, became the appendages of those particular dominant classes. Even the military, you know, you find in the article that Napoleon dressed his judges in military, you know, attire. So the connection here is really, and I argue towards the end that they were not interested in access to justice. It was just about power and wealth. And there has been a good deal of writing on the issue and how other jurisdictions have dealt with this issue and arrived at solutions. The case study of the UK, Europe, and America, I think, are given in that paper. And the dominant masculinities, women didn't become judges until much later. And there's a story about this woman who found that the robes, I think it's an American one, the robes were very masculine, right? So she had to design her own, which I think the writer says that they looked like a bath, what are they called? Bath what? Yeah. So that's the history of it, you know. And of course, the judicial attire and address impact access to justice, although this aspect is really historicized and problematized. And again, there have been, you know, a great deal of writing on that issue. In the Kenyan case, judicial attire and address has been a colonial, neo-colonial imposition. The Kenyan judiciary has not had any occasion before the promulgation of the new constitution to see issues as critical to the administration of justice. The Kenyan people had the occasion to address this issue when they were consulted in crafting the Bomas drafts of the Constitutional Kenya Review Commission. Kenyans called for the change of judicial attire and address. The idea to change judicial attire and dress is one whose time has come. We cannot, under the new Kenyan Constitution, impose a dress code, a new formal title on the judiciary. In the word and the spirit of the Constitution, we as Kenyans must debate this issue, engage the public, and reach a consensus on it. This debate still continues. It's of course the judiciary, I think, more or less sorted it out. But the bar is too wicked. And when I was in the judiciary and I used to swear advocates into the role of advocates, I was amazed at the shape and the colors of the wigs that they come wearing. And I always wondered whether some they were buying from Limuru. But wigs are expensive. If you get the small one, like the one that Githu Muigai wears, you know, barrister's one, it might cost you 5,000 pounds sterling. It's very expensive. So when we launched the Judiciary Transformation Framework in 2012 to 2016, this was one of the issues we took up. And the framework itself gave the philosophical and cultural orientation of the judiciary. I'm quoting that one. The philosophical and cultural orientation of the judiciary as reflected its founding history of dominance, power, prestige, and remoteness as opposed to service and equity. Further, the architecture, rules, dress code, and other rituals have uprooted it from social reality. As a result, the public perceive the judiciary to be alien and insensitive. In seeking to change this image, the framework will provide a clear philosophical compass for the judiciary founded on the Constitution and informed by the country's social context. The judiciary must be eternally conscious of its near sacred role as a temple of justice, and in dealing with the public must realize that people are not only source of its authority, but also the target of its service. The framework seeks to create a judiciary that is sensitive and responsive to the needs, feelings, and aspirations of the people. Further, it seeks to create an institution that is friendly and fair to people, both in the hardware of its outlook and in the software of its decisions and processes. So judicial attire has changed throughout history, adapting to new empowered governments, populist movements, and the popular fashions. Robes, wigs, hats, gloves, medals have been added to and subtracted from judges' wardrobes after the English Civil War, the American and French revolutions, and Napoleon's conquest. New leaders often seek to set the tone for their reign by introducing new customs or reviving them from the prosperous times. Modern judges often contemplate the effect their attire has on the citizens who they appear before them. So the relationship between judicial attire and access to justice under Article 48 of the Constitution, when considering the history of judicial attire, it appears that those who impose changes generally intend to distinguish their judges have their judges mimic others or project an image of their citizens. They may choose one or even all reasons, but most of the reasons detailed fit in one of the aforementioned categories. The most common and the powerful historical theme of judicial attire changes is the desire to distinguish a new reign from a new government often make drastic changes to attempt to show they are unlike the predecessors they replaced. When Charles II assumed the English throne following the Civil War and his exile, he sought to distinguish his new monarchy by discarding reforms made during the populist movement. Judges no longer adhered to the former 1635 dress code 168 and instead were encouraged to wear pompous falling raised bands and the newly fashionable French wigs to display the new government's grandeur. After the French Revolution, judges' scarlet robes and gold lace decorated hats were discarded. A trial course took place in simple black attire, while the High Appellate Court wore nationalistic tricolor trimmed light blue, and intergovernmental dispute courts wore pure white with tricolor trim. Napoleon, though, sought to break any potential monarchical resemblance of the judiciary. Gone were the reforms of the revolution, and all judges were to adorn simple black. After achieving independence from England, American judges eschewed the wigs and the far-lined scarlet robes they wore under the English control, and instead they wore simpler black robes or shed them all together. Attire can also distinguish judges from other judges, professions, and countries. Judicial attire can also distinguish court proceedings. Judge Bradshaw donned the unusual steel-plated beaver hat during the unusual trial of the English king for treason, as cow caps and the cornered caps have been worn at times in England when passing the sentences. And even in the modern era, English criminal trial judges adorn the scarlet robes instead of the dark navy worn in civil trials. The kings often clothed their judges in regal garments so that they would resemble nobles or royalty. Scarlet robes were thought of as monarchical in Italy and ceremonial in France. And both countries adorned them. Italian judges were fitted with garments suitable for senators, doctors, and knights, and the English kings bestowed robes upon their judges like French nobles and clergymen. Another common theme with attire is the desire to project dignity. And all these things I'm reading, the bottom line is they basically, I could sum up them by basically saying it's all, a class thing, the judiciary being enslaved by whether it's the monarchy, whether it's the military, whether it's the capitalists themselves. That is a constant theme that runs through this discussion. It's important not to overlook simple logistical reasons for changing attire. The smaller wig was cooler and more comfortable. The full-bottomed wig robes were not designed for the female figure. So, so they have, so as they have risen to the bench, female judges have sometimes adopted hanging neck wear to make the robe look less awkward. Now, this paper doesn't, and this is just updating it, that when you talk about access to justice, and you dwell on attire and address and dignity and whatnot, we forget the impact of court buildings as part of the discussion on justice. Has anybody here been to the Chief Justice Court 1? Have you seen the Chief Justice Court 1 in the Supreme Court building? Who has seen it? Yeah, it's a museum piece. Nobody sits there. But if you want to see a building or a court that reflects which a court that if you look at it, you can see the class nature of it. Because you see the judges in that court, when you sit, when you go there, everybody is down there, even the lawyers and so forth. And that's in terms of court buildings. The class structure is clear. The insensitivity of it, a lot of those courts didn't have access. They don't give access to people with a disability. The High Court actually had to, to do that. The Supreme Court building, if you look, there is a place where, the people who have wheelchairs and so forth can get to the courts. This was because there was a judge called Sheridan who was in a wheelchair, and they had to take care of him. And later there was a judge called Sultan Aganyanya, who also was in a wheelchair. So in his case, they installed a lift. But most of them didn't have those, particular facilities. So the buildings also have to be looked at. And we had a contest where we asked people to design what they thought was a pro-people court. If you ever get to Germany and you go to their constitutional court, you see what I mean. That court is built in such a way that the transparency, if judges are sitting in their chambers, it's like they're being watched, because it's well lit, and I guess it's a way of saying that the judiciary is incorruptible and it has integrity. So we should focus on that as well, because I think it's important. So while those in power may have specific reasons for why they want distinctive judicial attire, there are consequences, sometimes unintended, that should be considered. On the positive side, robed judges might appear prestigious, cultured, or dignified. Since no other profession wears them, judicial robes truly do announce that the court is in session and that its wearer will seek justice. Perhaps most importantly, the distinctive black robes can serve as a reminder to the judges of the importance of their responsibility to administer justice and not perpetuate bias. On the other hand, judges who become less formal by removing robes or simplifying them might appear less pompous and more human. The negative consequences of wearing formal attire seem to weigh heavier today. It is important to remember that when judges initially wore formal attire like robes and wigs, other professions wore them as well. However, those fashions faded centuries ago. Today, when those who have never before walked in court make their first appearance, it's likely that the formally outfitted judge, perhaps wearing a wig and robe, is the only robed person they have ever seen. As English documented when studying this issue recently, people can indeed be intimidated by such formal attire, instilling fear in a court participant, whether in criminal defendants, witnesses, or young and experienced lawyers, undermines the very purpose of judicial systems to administer justice. Judicial address. Judicial address. It's a. Let me just give the background of it from the English perspective. If you study English history, particularly under feudalism, the lords of the manor, as they were called, had their courts. And the serfs, who were the equivalent of slaves, except, they were free, would be subject to the landowner, or they might be knighted by the king. And so you meet this guy who is in charge of the court as bishop on Sunday, and on Monday is the judge. And since he's knighted and he's Lord Osogo, it makes sense to call him my lord, and if of course there were no women judges, so my lady came much later. And it makes sense to know that the origin of that is basically issues of title and the status in society. And because he was a bishop, this language you hear in court, my Lord, my prayer this morning. That's the origin of it, because you're talking to a bishop who is playing God. And that's that history in our debate in 2011 became very, very important, because a lot of people didn't know it. They didn't know why judges wore wigs because of the weather. Okay. I couldn't imagine how our judges in Mombasa and Kisumu will wear wigs and not faint, or people scratching themselves. But that's the genesis of it, and how they were to be addressed, of course, was important. Dear Lord Chief Justice, my lady, dear Judge, Your Honor, and there were these, categorizations depending on your status as a judicial officer, or, as a judge. And we had to deal with, those issues, because some people in the judiciary really cared about those, titles. I remember one of the judges was appointed when we started, and he was a magistrate. And we said everybody becomes, will be referred to as, Your Honor, Mheshimiwa. So he came to me and said, this can't happen to me. For 25 years, I've been called Your Honor. And for the last 3 months, I was called My Lord. And then you say this shouldn't continue. So there were, people who felt that this should not happen because I guess they didn't look at the Constitution, the Article 10 about inclusiveness, about equity and equality, so that a Qadi or resident magistrate or whoever should have the same title. And this one we borrowed from the Americans, actually, because the Americans, when they won they defeated the British, they did a lot of things. They didn't wear wigs. They had robes. And you see, robes are, fairly comfortable because nobody knows what you are wearing underneath, particularly if you are in hot places. So you have seen movies where American judges wear robes, but they're wearing jeans or shorts. We also told our judges that the Indians didn't use the word "my lord" or "your lordship" or your honor. So that's the basis of it. But we ourselves thought that Mheshimiwa is okay. MPs are Mheshimiwas, the ministers are Mheshimiwas. So we thought it's a way of treating the entire judicial, the judges and the judicial officers as equal. Now, in that paper, I also tell the story of the issue of dressing the Supreme Court. As you know, 2010 Constitution gave us a Supreme Court. It was new. We didn't have a dress code, so we decided to use that opportunity to debate, what will be our dress and our dress. So we, the way it was done, the debate took place August 2011, and I wrote a draft of this paper to convince the judges that we needed to discard wigs and British marindas, as we call them, scarlet robes, and it was a very robust debate because there were some judges who were basically saying no. They would have supported what Kuloba says in the paper, because Kuloba says that one you once you wear a wig, you become smarter. So that debate, in that debate, we reached a consensus that wigs will not be worn, and the scarlet robes, will not be worn, and they will be surrendered to the Judiciary Museum. But I still regret that I didn't collect them myself, because they still kept them for use in a rainy day. There is one detail I forgot to tell you. When I was being the day I was sworn in as Chief Justice, in the judiciary, there was somebody who was there to dress you, so that you could have the wig, you could have the robes, and he would hold the mirror so that you can look at yourself. So when I got there, he told me, "Oh, so can I dress you?" And I told him I'm already dressed. So, and if this is what you do in the judiciary, I think we're going to transfer you. And he turned to Nancy Baraza, who was the vice deputy chief justice, and she also said, "No, we're just going to wear suits." And I in the legal profession, I always resisted this dress code by lawyers for wearing pinstripes, what they call sober colors. So I actually wore a green suit and what's orange shirt and some tie, really good camber colors that I wore there. Just to make the point that the Constitution had an article in Article 27, which said you can't be discriminated on the basis of dress. Okay, and this is a judiciary. As Joy reminded me, where women were not allowed to go there with you plaited. You couldn't plait your hair. And if you had dreadlocks, you wouldn't be heard. Okay. And so there are some people who decided on these issues, and I wanted to resist them from the beginning. Anyway, we decided that we get people to design robes, and we brought in artists and all manner of people to take care of that. It was a kind of a public participation in in the robe that that was ultimately accepted. And then we wear the robe and we ask people to to comment on the new robes, and what they said was not flattering. The robe was green in color with some minor gold embroidery. It was simple cotton robe, light and inelegant. And the Supreme Court picked green card because of the color of those who voted yes in the referendum 2010. And more importantly, the judges saw the colors that the South African Constitutional Court had chosen. At that time, the South African court seemed an obvious model court in its attire, its building, and its jurisprudence. And green also symbolized a healthy environment, beauty, plenty, freshness, and colors of the peasantry, common folk, the wealthy and the mighty, a color that promoted the constitutional value of inclusiveness. So we appeared wearing those robes on November 15, 2011. And as I said, the comments from the public, and I'll read some of them, not. So the Star, in its gossip column, appropriately called Corridors of Power, wrote of the robes, the new robes of the Supreme Court judges, which start officially for the first time on Tuesday, have been the cause of debate in the court corridors. A senior lawyer who watched the proceedings from a vantage point said, the robes, green and gold with black binding and something called made judges look like the prison squire and did not reflect the dignity and soberness of the Supreme Court. The others actually who said that if you were given gumboots, you will look like city council askaris. And somebody else was rude to say that, you know, we looked like characters in a Nigerian horror movie. The Sunday Nation quoting a reader in popular column quoting the cutting wrote, "These Supreme Court judges wear a robe that is mainly green and resembled that donned by a Catholic priest during the Mass. Who designed this robe and what do the colors signify? Is the coat of colonial wigs being replaced by one of robes? Why can't judges wear plain suits?" And they said, "Over to you, CJ Mutunga." The Daily Nation in the same column quoted yet another reader saying, "The green attire would have been okay for members of a choir from the forest department singing about trees, or officials of a school or college environmental club. I prefer the red attire which displays authority and sanctity of the court." That must have been written by a lawyer. CJ Mutunga, let's change with a touch of style if we must change. The blogger repeated similar negative comments on the robes appearing in various media and concluded, "There you have it, Kenyans. Kenyans are not impressed with this activism." Some of the judges were happy that the public criticism likened them to ordinary, humble people with a calling. Others felt that it was time to choose robes that would restore the dignity of the Supreme Court. So let me, conclude, because you already have the paper. While I've not found materials that squarely address whether there is, in fact, a relationship between judicial attire and access to justice, my research leads me to believe that overly formal attire has an inverse relationship with access to justice. And from the early days of secular courts, authorities were concerned not with providing access to justice for the benefit of their citizens, but with reinforcing support for their power. Robes and other formal wear were borrowed from clergymen to create the perception of a dignified reign, from the nobles to display their reign's wealth and power. The intentions of the states enhancing judicial formality have often appeared manipulative rather than benevolent, and the consequences for citizens are more often negative. Simply put, formal attire that lingers from different countries, centuries, and global structures does not symbolize access to justice for the public. A humanizing and a contemporary approach seems more appropriate. Yeah, and I go on to say that I really loved being called Ndugu Jaji Mkuu, Babu Jaji Mkuu, and other judges, of course, liked it. So this debate on dress and address of judicial officers hardly scraps the surface of the conservative judicial culture of the Kenyan judiciary that is slowly being transformed. This culture has its hallmarks in insularity, impunity, judicial and intellectual laziness, self-centeredness, arrogance, insensitivity, and failure to recognize its pro-people calling. Transforming this culture is fundamental to the transformation of the judiciary. Gone are the days when women were not allowed to plait their hair. In those days, though, those who had dreadlocks had issues of accessing courts. And as I said, that is history, because Article 27 now does, protect those rights. And of course, I haven't said anything about the bar, because the judiciary decided that we wouldn't ask the bar how to dress. But in the Supreme Court, we didn't allow them to wear robes or wigs. We said they should just wear suits, and that was it. When it comes to the bar, I think they have to, they have to deal with this. It seems that the British have abandoned the wigs, but they know there is a lucrative market in Africa because all jurisdictions have, particularly the bar now, they have to start that debate. You have to start the debate, advocates, on whether you want to decolonize the law, decolonize your minds, and what these wigs are for. Okay, and there can be pros and cons. I remember there is a case I lost when I practiced law in 72, I think it was, and the law society decided that you could actually appear before court without a wig, and I didn't have one, so I went there. The advocates on the other side had a beautiful wig, and he won the case. So my client came and told me, "Why didn't you wear the wig?" So I guess those who are practicing, they might think that, as Koloba says, those who wear wigs are brainy and they will win their cases. Let me stop there, and if there are any burning questions, I think you can ask a few, and thank you very much for listening to me.
Round of applause for that presentation. Thank you, CJ. I'm aware some good research went into that, and it's been an interesting one. We have laughed, we have reflected, and now, as you have correctly mentioned, we can hear some burning questions. I see that in our midst, we have Kabarak University Provost, and I would like to invite him to say something. This is a tyranny. You have to say something by order of the moderator. Welcome.
I will make a comment. I wanted to be here before it starts. I have an interest because church, we have questions on the church also with the issue of grace, because I think colonization did not only go to the legal, but it also affects us as pastors, and I have a lot of interest in that, but I will be making comments. I appreciate the portion of sharing where I found you talking. I have my pertinent concerns, not for now, but thank you for allowing me to be here just to be a participant. I will be raising concerns later. Thank you.
Thank you. Thank you very much. Thank you very much. Burning question. If you don't ask, you may faint. Yeah, someone here may faint. Bring him the mic. As the mic comes, Provost, it's good that you're here, because as CJ highlighted, there's a huge relation between the dress and address of judges in the church, and some of its origins can be traced to the church. So it's very good that you're here. Now on to the gentleman who will faint if he does not ask his question.
Okay. Thank you, first of all, so much for that recount, Prof. CJ.
Maybe you can stand and face the camera as you ask.
My name is Alex Tame. I'm a second semester student. I'm sorry for the problems I had standing. The questions were written there. I was thinking them through as you went with your talk, but it's fine. I have two.
It is so ordered.
Much obliged, Babu Jaji Mkuu. So my questions were two. The first one is on constraints, and the second one is on this concept of autochthony. The first one is a conversation I was having with my teacher, Professor Ambani, last night. I went through your paper, and then I read the Judicial Transformation Framework, 2012-2016, and I absolutely loved the ideas in it. And it just so happens that I was doing research similarly. And from other conversations I've also had with my other teachers, Moli Musipala, I came to, there's this phrase he used that I love so much, that most problems in Africa are in fact not a hardware problem, they're a software problem. And it struck me that my problem with, dare I say you, is you went systematically, beautifully, amazingly to solve what was underlined by a software problem. And you did it incredibly well, such that at least in the building standards, I've been to the High Court, the new building, the new court building at Nakuru, the Kibera Court. It's this thing I always tell my professor. It's representative of your philosophy. It's visible. But on the dress aspect of it, and to some extent, I would think the address, when you left office, it ricocheted back to what it was. As you mentioned yourself, the robes came out of the woodwork. The address went back to my lord, and the circumstances went back to what they were. And that brings my question on constraints. It's this management philosophy. It says you can only effect change from the tightest possible bottleneck. And I found myself convinced that the tightest possible bottleneck, in fact, is not in the physical manifestation of neocolonialism and all its problems, as you've so aptly titled it, but in fact in the defunct mental models. And that's where my problem has been at. And I've just been trying to hound my teachers for the past week or so. How do we solve not the manifestations of the problem, but how do we solve the very defunct mental models themselves? How do we replace them? And that ties into my second question. My teacher of jurisprudence impressed upon me this concept of autochthony, and it made a lot of sense in the sense that I'm sure you understand Mr. Ongoya, the way he grounds things in the way they're no longer abstract, they're just common sense. It's like something that is in the lived experience to the extent that it can diffuse even into the bloodline of a people. You can try for hundreds of years to stamp it out, right? But in the grand scheme of things, when that effort to stamp out an issue goes away, then what was diffused in them to the extent will just come bubbling back to the top, right? And so in a sense, I feel the recanting, if I may call it that, the return to the status quo for the dress and the dress reforms that you initiated. Do you feel what ways could you have made it more autochthonous? Maybe now public participation on a much, much, much grander scale, like we've seen with the GenZ revolution going on, where the president has had to shuka himself to the X spaces to have a conversation. Is there any reflections on making it more grounded in the heart of the very people themselves, such that the reforms are brought forward into the future hundreds of years after you yourself, Babu Jaji Mkuu, is gone? Yes, those are my questions.
I think it would be wrong to look at the judicial transformation, by emphasizing one issue, right? There were a lot of issues that we dealt with. Okay, it's so. In fact, I remember, when this discussion happened about dressing and addressing the judges and judicial officers. There were a lot of examples from our own African traditions, right? I remember telling people that if you go to any a community or village where there's a dispute, okay, there's a dispute, maybe cattle trespass, and the elders are sitting to decide, who is wrong and who pays what. If you are not part of that community, you can sit, listen, and participate, okay, in the judgment. Because African dispute are settled on the basis of restorative justice. You know, people live in a, in a community, so the adversarial method, creates enmity and destroys peace. I also talked about the Kadhi courts, which are used as examples. I said, if you go to a Kadhi court, so it's very difficult to know who the Kadhi is, because the Kadhi might be wearing a kansu, right? And the people, the women are wearing bubuis, and they are seated, around a table, okay? So you don't, that kind of equity and equality, right? And human dignity for everybody. There were examples we discussed, and that's why I was emphasizing the whole question of demystifying the judicial culture. That's how, we didn't crush it, okay? We didn't crush it. We didn't persuade people that, they look ridiculous, when they are still wearing, wigs, when the British themselves don't wear them. All those discussions took place, okay? But there were some people, colleagues that I still remember, who saw what I couldn't see, in wigs. And so I think that the transformation was, and I guess coming from the university and so forth, we were supposed to be incited and excited by ideas. And looking at the constitution and looking what was going on, and the fact that the people themselves, the Kenyans themselves, had said that they don't want to see the British maridas and wigs, because a lot of them, particularly from the Kikuyu community and those who are in the Mau Mau, were sentenced by, judges who wear wigs and those scholars. So those scarlet, scarlet robes. So there was a basis for people to basically, think about it, and that's what status quo does. All right, any progress has its twists and turns. All right, the GNC will tell you that, twists and turns. The question is to where, right? So I think we were very persuasive. We tried to be very, very persuasive. But because we are external, and the judiciary was a different judiciary. It's not what it is now. There were no people from the academia. There were no people from corporate sector, from human rights. It was just judges starting as magistrates, and then judicial officers becoming judges and so forth. And when you are engaged in transformation, you persuade, but you can't basically do anything about the reversals. But there is a group of people in the judiciary who still believe that wigs are not for the judiciary. Definitely, the Chief Justice Kome, she told me that her hair, what kind of hair is that? Eh? Yeah, sister locks. Yeah, she said she won't have a wig on her sister lock. So there's a group there, And so my answer is, it's not that we didn't try, right? We did, we tried. And sometimes you cannot open battles on different fronts. You have in this country, you have to at least get one thing and finish it. And I think we're a country that, because of our politics of division, it's very, very difficult to get people to basically, accept that you can't do everything. But it's still an issue to be, discussed. And so when you look at the transformation, I think what you are saying is correct. You should look at, what succeeded, the gains that were made, and the weaknesses that can be, rescued. I think the Supreme Court still doesn't wear wigs. I know Judge Maraga wore them, but they were ceremonial, rather than, the colleagues in the court told him that he couldn't wear them. Yeah, I think the bottom line is that we persuaded. And yeah, the transformation guys it could be, there were professors there and other people, so it's possible we were, a bit abstract. But yeah, I mean, can you imagine the only thing that people think I did in the judiciary was to dismiss Odinga's petition? And that's the only thing they remember about me. So Kenyan public is it's very difficult to please, particularly our generation. I think the other generation will be pretty fair. At least when somebody asks me what my contribution was, and I'm always happy to say it, is how within 3 years I was able to convince my colleagues on the theory of interpreting the Constitution and how it should be done. And then the digital migration case, we say this is how it should be done. Yeah. Thank you for your question.
Thank you so much. I see Senior Majanja has something to say. Perhaps maybe I should mention that we would have loved to have a very robust discussion. We'd probably have it another time. We probably should schedule another one. But for now,
question,
yeah, we'll take 2 more questions and then we'll move to the next segment.
Thank you very much, Professor CJ. My name is Majanja Kelly. I'm a member of faculty here at Kabarak Law School. Maybe just to ask my question, looking back in retrospect, do you think, Chief Justice, that it would have helped if the idea of decolonizing or having the dress code change would have worked if it was an engagement between both the bar and the bench? Because we seem to be dealing with an issue whereby, yes, a number of members of the bench agreed and thought that this colonial relic or regalia is something that we need to put away. But we from the bar still remained with that notion that for you to come to court, you have to be in this white shirt, dark colors, so that even today, if I'm as an advocate, I wouldn't, it would be a great risk, even if I wanted to go to court, say, in an orange shirt, then the thrashing I would receive would cost me just the same way it costed you without the wig on that time. So that my question could it have helped if the bar would have been involved in this conversation
so that it is not just an issue of decolonizing the bench, but also decolonizing the bar. Because we are now dealing with a situation whereby the bench is slowly being decolonized, but the bar is still colonized, so to speak. Thank you.
Yeah, we can take one more and then CJ can answer them all at once. I see a lady there who looks like she'll die if she does not ask a question or make a comment. And may I just notice that she has dreadlocks and she's preparing to be an advocate of the High Court of Kenya. Viva, welcome.
Good afternoon, everyone. It's so nice being here. This will always be my home. Atam nikatae nitarudi prof. So atam funge get nitarudi. But I think it's going to be quite the anticlimax that you introduced me that way, yet I'm here to dissent, which seems to be my job nowadays. But I want to ask, but as well comment on the lecture from the perspective not so much of decolonization, but a question of what is the point of the signification that happens with dress, address, architecture, all of those things. Because I think it can at times get lost that those things are not there just for the fun of it. And I think I would like to point to the, but the other side of access to justice is the delivery of justice. It's not just a question of being approached, it's a question of the decision that is delivered by the court, and most importantly, the legitimacy of that decision, and crucially, its enforceability. And to be able to do that, if I show up to court one day like this, and then I am reading the death sentence to somebody, there is something off there. And more so in today's world, where we have criminal trials happening via Zoom, where there are advocates seated in their car, addressing the court. Wengine, there are children in the background. We see these things in practice every day, and now it has become a fun thing to do on WhatsApp, to send the latest WhatsApp of the client who showed up to their divorce trial with their wife in bed. There's something that is lost when we cheapen really what is, and I will go back to the religiosity of it, what is a near sacred, as you said, Chief Justice, a near sacred duty of the court and the lawyers. In my research in this subject and my understanding of it, maybe it's my very young brain still, but there's something to disappearing inside the robe that when, for instance, you delivered your judgment, for all eternity, it will be the court said, not CJ Mutunga said this particular justice said that, the court said. But for the court to say, then I cannot really be concerned about my hair, because I am there as the justice that speaks as the court, not as an individual. So what is to be said of that? Because my fear is that in the discussion about decolonization, we can come to a point where we basically make everything profane and say there's no point to signification. My particular position, I am all for symbolism, but make it inclusive. Not so much inclusive, but for this place, as with your robes, not disappear the robes, but make them mean something here. The question becomes, how do you balance the needs of people to approach the bench, but also people do not come to court because the court is nice. They come to court because the court has power that they don't have, that their elders really do not have. People come to court with their criminal problems, for instance, because they want someone to be put in jail. Really, they do that. I don't think people are as nice as we make them out to be. People go to court for power, and power needs to look a particular way. At the cost of entrenching my position any further, let me point to the Hobbesian attitude towards the state. And one thing that I find fascinating that I think gets lost a lot, it is not in the enforcement, it's not in the living fact of force that the state gains its legitimacy. It is in creating a sense of awe, a sense of symbology. If we get rid of that, if we tear the curtain of the temple and show everybody what's happening behind the scenes, if we remove the wizard, if the wizard is exposed, the Wizard of Oz is exposed for a charlatan, which is what the what the transparent glasses in modern courtrooms look like, then what do we have left? Because unfortunately, people want power, and that's why they come to law for power to work in their interest. When we remove that, what are they coming for? Does it not look capricious, arbitrary, without dignity, without divinity, as law really pretends to be?
Maybe CJ, as you answer that, I can also address to you a question from a participant on Zoom who asks, perhaps you can also talk about the dress down Fridays, which apply to staff, and also whether dressing and addressing concerns should be concretized via policy or such like. Welcome. Hey, I don't know if you heard that. Prof Ambani is asking me if he can ask a question, and then he said if he may. Now, for those of you who don't know, this is my boss. This is my moment of fame. This is my highlight of the day. Professor Ambani, what were you saying? If you may, kindly, you may for a minute.
Thank you.
I'm watching you.
I'm sorry, I was going to shut up because I know we have to move to the Gen Z discussion. But as they spoke, there was some fire inside me, and I wanted to ask a difficult one for me. We also do graduation, and there's a way we dress. And it's also colonial and also goes back to the church, I believe. But I want to agree with Lizzie. Supposing I was show up in a vest and want to award a degree of Doctor of Laws to a former Chief Justice, don't you think that there's a lot of decorum lost there? Or what is the extreme? Supposing I came with vest was one extreme, and the other extreme, those robes and wigs. Is there something in between that you'd suggest, or you still suggest some robing, or so long as it's in cotton and stuff like that? And is your theory good for the other sectors, like mine, university, or like for a priest? I know the Protestants don't have to do that anymore, but still on big occasions, they'll still do something ceremonial. Yeah. So I hope you were able to address my concerns. Thank you.
Let me start with my friend Malenya. It's a great question. You were asking why didn't we involve the bar at that particular point. The reason why we didn't is that the bar had already dealt with that issue of the wigs, right? And they made it optional, which was progress. Okay, that it wasn't compulsory that you wear wigs when you go to court, and they talked to the judiciary, and the judiciary, accepted that. We also thought that it was, a better idea to deal with the judiciary, upfront, and not drag the bar into that discussion, which was peculiarly, judiciaries. So that was vision, for it. Create that rule that nobody would wear suits and so forth, right? So we thought, that was an issue that needed to be, dealt with in a persuasive way, rather than saying, well, if you come to the Supreme Court wearing wigs, we won't hear you. We knew very well we couldn't do that. If somebody came wearing wigs and so forth, we just said, but you look ridiculous. Why don't you just But as a strategy, I think probably now is the time to, to discuss this with the, with the bar and see what the LSK and the senior counsel bar say about it. The dress down on Fridays was just about this is I think we were very obsessed, no, not obsessed. The fact that we wanted to show that the judiciary was changing and it wasn't opaque and the judiciary was pro-people. This dressing down was part of the reforms we made, like the one on pledges. Those of you who went to court, the judges and magistrate will read a pledge that had 6, conditions, just, to make people, comfortable. Because a lot of people went to court, quite a number of them were jailed for contempt of court because their phones rang, or because, like the story that is told of a Luo elder who I always like telling, of who walked into a district magistrate court and greeted them in the Luo, and so he was charged with contempt, and it was being taken to the cells. He asked, what kind of court is this that doesn't allow people to greet others? So we were saying even the clerks need to relax when they serve the public, and the idea was just to make people feel that the courts were changing and they were being friendly, and the fact that the staff requested that, and the JSC and us didn't see the reason why we want to do it. I think Liz, yours is philosophical, and I mean, it requires discussion. For me, the most important thing that made me get to this debate was just the access to justice. Making sure that when people went to court, they didn't feel intimidated, they didn't feel that they were not going to just to get justice. And the notion of power remains with the judges. It doesn't remain with the ordinary people, and that's what we're focusing on. And so access to justice became very important to us, and it became important to Maraga's tenure and also Kome. That's why we started the whole issue of African justice system, which is fantastic, because it's gone to a stage where we realize that 90% of the people who have disputes don't go to formal courts. They go to the elders. But I agree with you that just like the first question that my friend asked, it's a process. Okay, it has its twists and turns, and the point I was making is that this discussion it's now become a people's discussion. It wasn't there before. It was imposed upon by either colonialism, new colonialism. But the fact that people understand now that we value during Jeka, we value the Borana, council of elders, and that access to justice or justice to all is not just the, the 5%, which is which gets to formal courts. And I think I would say that the jury is still out on some of these issues. And that's why I've used the metaphor of twists and turns. Sometimes you don't know to where. But as I've said, we wanted to demystify the judiciary, make judges human, and not the guys who looked aloof, we wanted them when they went to church and they were asked questions, they will answer them. Yeah, and they say the struggle continues, right? The last one, Dean Ambani. We at that point, we were not looking at the theological class and also the university. And I guess, you remember when I came to the graduation, I only accepted to wear the university robes because they wanted to take a photograph. Otherwise, I wore a judicial. Maybe I'm allergic to them. I don't know, but we didn't extend it to the lawyers. We didn't extend it to the clergy. We didn't extend it to the universities. Okay. We confined, but I'm sure those debates can happen if they are united. Okay. I think somebody said that in churches there are a lot of pastors now who don't wear robes. They just wear smart suits. Okay. But those might be those who believe in prosperity gospel, just to basically to show that you have to shine. But if it's the Roman Catholics, for example, or if it's the monks, Buddhist monks, and it might be very difficult to say that debate there, because there's the issue of divinity there and the values, religious values, and so forth, which were not implicated in our debate. Our debate was basically to tell everybody that we need to be pro people, we need to have a friendly, environment. And if Kenyans were saying, why are you still wearing the dress that was used by the colonialists to oppress us and to hang us? What reason could you have given? So that will be my take. You don't look persuaded, so I'll persuade you later.
Wow. Thank you, CJ. Thank you so much. I see we have more questions. I see we have someone who I must single out because they're not from the legal profession. There's a time we have spoken about having interdisciplinary conversations, and this seems to be one of them. So on behalf of everyone who would have wished to ask a question, actually, scratch that. Our provost must speak.
No, I just wanted to say something a professor mentioned very briefly. I guess, Professor, what is happening with our time is theologically, there's a theology of the cloth and all that. We have that. But I think we also became victims of colonial waves, and our theology was moved. Even the theology of clothing with the clergy and all that was swept away by the influence of colonial forces when they were intertwined with the missionary waves. And so you are right, today there is so much that there are churches where if I went the way I am with a tie and a shirt, I would be excommunicated right away. I grew up in a setup where if you came the way you are, Chief Justice, then the elders will get you a tie from somewhere in the vestry so that you become part of the story. But I have a very strong feeling that there was a functional, a functional role of clothing, a ceremonial part. But I think even for us theologians, even as you look at it from the legal practitioners, we've lost something. Some of that has become kind of a discriminatory. If you look at, let me give an example of the church that I am a member. We've even placed those clothings different colors, and the different people are perceived as possessing certain rank depending on the cloth they use. And I don't see that in the theology of clothing as I see it coming, because when I look at it in the Old Testament, that I don't see. That's part of the reason why I was very interested to hear what your discussion and conversation on this direction will be, because we also hope to originate a conversation on the same. If you look at the West today, these guys are preaching with jeans and hanging shirts, but they left us here in a hot climate with ties and suits and gowns. And you are judged for that. Even if you look at the YouTube today and see the preachers, you just wonder if from the world view we were given. So I just wanted to make that statement. But again, like my sister was trying to say, we're also very keen that we don't lose the essence. What value is attached to clothing theologically? That's from my point of view. So yes, I don't want to enlarge the conversation from there, but I just wanted to echo the statement you say. Yes, we are seeing that wave of a lot of some are perceived as rebellious for not using those gowns. I know clergy that have never used the collar, because that collar is in some places is associated with a different sort of ethos of colonialism. So just a general statement. But I also think for us, we lost it at the hermeneutical level, the interpretation of the clothing in terms of the scriptures. So just to shed light from my end. Thank you.
Just a point that a comment. I've read quite a number of religions, and there's one common denominator: the values. Whether it's African, whether it's the Protestants, the Hindus, you can count, the values and how they are anchored, to humanity, and particular models in the scriptures, whether it's Jesus Christ or Muhammad, who should be our models. And to answer Liz, I think it's the same thing. It's we look at what are values in the justice system. Okay, what is it that is the core of the work we do? Because the whole debate on the dress and address, okay, if it misses, the core value of access to justice, okay, and humanity in it, so it's a debate, in a vacuum, okay, and that's why I wanted to make that comment, so that you also feel that I understood where you're coming from. Thank you.
Thank you so much. Thank you so much. On behalf of everyone that would have wished to ask a question, those who have asked questions, but unfortunately, time is not our best friend today. We should surely have something later to just continue this discussion, since it has a lot of public interest. Thank you so much to everyone who's joined this discussion. But this is the most appropriate time to say last but not least, because this is the last segment of the first discussion, but another one is coming. soon right after. We are discussing the one thing that nobody can avoid at this time in this country, the Gen Z revolution. Before we do that, we understand that you have been seated for quite a minute, so you can have a 5-minute break. Then we can reconvene to talk about the Gen Z revolution. I know there's some news circulating right now. Someone has even commented about it on Zoom. Hang in there. Hang in there, our audience. We are coming to talk about the thing that seems to matter most right now in this country. Just, yeah, let's reconvene at 4:25 p.m. East African time. Thank you for now. And let's see each other in 5 minutes. Yeah. Thank you. Meanwhile, we can appreciate the Chief Justice and yourselves and the Professor Ambani, who had the pleasure of asking me to allow him to speak today. You must be honored. Thank you. You can all stretch and let's resume the discussion in 5.